principle in Calvin's case, which is essentially the exact same principle that Justice Marshall adopts in Johnson v. McIntosh. In fact, this is the first legal precedent in English that adopts the doctrine of discovery, Calvin's case. All infidels are in law perpetual enemies, forever. In other words, you're always going to be at war with these people. The law presumes they won't be converted. That's a remote possibility, because as with devils whose subjects they be, and Christians, there is perpetual hostility and can be no peace. And this is what's important. Therefore, a pagan cannot maintain any action at all in the king's courts. Under your Indian Act until the 1950s, it was illegal for First Nations to hire a lawyer. The precedent, Calvin's case. First Nations, before your Constitution, could not sue unless the Crown waived its sovereign immunity. The precedent, Calvin's case. And then look what he says. This is exactly what Canadian law says. If a Christian king conquers a kingdom of an infidel and brings them under his subjection, there, ipso facto, the laws of the infidel are abrogated. In other words, your property laws don't exist anymore. The ways in which you regulated your family relations, the ways in which you chose to educate, it was all wiped. At the moment you are discovered, everything you had that you thought was a law is abrogated. It is not recognized, because under this doctrine, you have no rights. For that they be not only against Christianity, but against the law of God and nature contained in the Ten Commandments. And in that case, until certain laws be established amongst them, the king by himself shall judge them and their causes according to natural equity. And of course, the joke that lawyers tell is that equity is the length of the chancellor's foot. Totally, in other words, the king is not constrained by law in the ways that he deals with savage peoples. He can do it according to what he thinks is just. That's exactly been Canada's approach in its denial policy to Aboriginal title since the 1800s. You're just following Calvin's case. I tell my native students in Arizona, don't be overly impressed by Western civilization. They're very static, not very progressive culture. They're sort of sticking with the same stuff they've been using for a couple thousand years. Just wait them out, they'll go away. Okay. Now what's interesting is to compare how Europeans were treating each other at the time that these doctrines were being promulgated into English common law. International law scholars will tell you that the modern European state system was established by the Peace of Westphalia. It ended the wars of religion between Protestants and Catholics, and this was a multi-party treaty. If you look at the map, you can see that the treaty pretty much adheres to the basic map of Europe today. That's why international law scholars worship this treaty, because it established some clear principles which made it possible for Europe to progress and not be at constant war with each other. The sovereignty of nation states and the fundamental right of political self-determination were recognized. Obviously, that's not what the doctrine says. Legal equality between nation states. The doctrine doesn't recognize equality between indigenous peoples and Europeans. Internationally binding treaties between states. I just cited you that Micmac case. Your courts held prior to your constitution, repatriation constitution, that treaties were simply domestic documents. They had no international force. Non-intervention of one state in the internal affairs of another. And of course, that's all the doctrine does, is allow intervention. And whose rule is religion? That religion would no longer be the basis for war between European nations. And it was the primary basis for European war waged against indigenous peoples. So we have what international law scholars call a radical asymmetry. Okay? You treat us much different than you treat each other. And yet you say that you're following the rule of law in your international law. And so now we get to British Columbia. Joseph Trutch. Interesting about Joseph Trutch, this was the guy who was the Commissioner of Land Works for the colonial government of British Columbia. And it was Trutch who implemented the doctrine of discovery in British Columbia. Now, interestingly, before Trutch came here, he had spent time in the Oregon Territory. And his memoirs and other writings show he was intimately familiar with U.S. Indian law and the effects of the doctrine of discovery and how effective it could be in extinguishing native title or not even having to recognize it. And so he says of the Indians, they're the ugliest and laziest creatures I ever saw, and we should think of being afraid of our dogs as of them. That was his view, that was his little love letter to his wife. I don't know if that turned her on or what, but there you go. This is how they talked to each other back then. And then look at his views when he later becomes commissioner. He's now formalized them. The Indians really have no right to the lands they claim, nor are they of any actual value or utility to them. They're uncivilized. I cannot see why they should either retain these lands to the prejudice of the general interest of the colony, or be allowed to make a market of them either to government or to individuals. Remember, Justice Marshall said Indians can't sell their lands, do whomsoever they please. Trutch is simply implementing Johnson v. McIntosh and the Doctrine of Discovery as official land policy, and that's why treaties were never signed. Except for those few Douglas treaties, that's the reason. This is the guy who brought this doctrine into Canadian law and British Columbia law and used it to argue against signing treaties with First Nations. And so in fact, Joseph Trutch takes a look at the lower third of Vancouver Island. That area in yellow is the claim that the Hul'qumi'num Treaty Group has put before the British Columbia Treaty Commission. This is their Aboriginal title. And Trutch, along with Lord Dunsmore and Leyland Stanford, was part of this corporate syndicate. Stanford, of course, founder of Stanford University, and made his fortune in railroads in the US. And he made his fortune by convincing Congress to give him large tracts of Indian-occupied land to finance the construction of the railroad. Gee, so where do you think they got the idea for the E&N Railroad? They proposed the same thing. Give us all this Indian land, and we'll finance the construction of a railroad with the proceeds of the sales and the mineral rights. And so, by the E&N Railway grant authorized by Canada's legislature, all that area in green, and much else. This is just the area claimed by the Hul'qumi'num. The grant extended far beyond those boundaries. But you can see that the grant of the E&N Railroad not only took the heart out of the Hul'qumi'num traditional territory, it took it all. Later legislation, in fact, took away their title and rights to the Gulf Islands. And so what had originally been this area of Aboriginal title was reduced to postage stamps. These little areas here. That's all that they had left. And not one dime of compensation has ever been paid. Because, under British Columbia's interpretation of the Doctrine of Discovery, if we don't recognize Aboriginal title, it does not exist. And that's the principle, of course, which flows from Johnson v. McIntosh. The exclusion of all other Europeans necessarily gave to the nation making the discovery the sole right of acquiring the soil from the natives and establishing settlements upon it. It was a right which all asserted and all others assented. And this is what's important. This is why, for 150 years, Canada could deny the title of Aboriginal people. Because those relations which were to exist between the discovered and the natives were to be regulated by themselves. Remember Calvin's case? The king can judge their cause by natural equity. This is the embodiment of Calvin's case. You can do whatever the hell you want. And here's the mystery. My students say, well, if there's a doctrine of discovery, why did white people sign treaties? That's what you have to understand. This is how you get an A in my federal Indian law exam, if you understand this one. Okay? Because what that says is, once you claim title by discovery, you can extinguish the native title any way you want. If they're powerful and militarily strong, sign treaties. Then weaken them and take the rest of the land away. Or you can go to war. Because they're infidels, you're in perpetual war with them. Or you can do like General Jeffrey Amherst did and give them smallpox blankets. You can commit acts of genocide, ethnocide. It doesn't matter. Because once they are under the jurisdiction of the Doctrine of Discovery, they have no rights under international law. And they only have the rights under domestic law that you give to them. So that's why you get this uneven treatment, that the doctrine gives total, unfettered, unregulated discretion to Canada, the United States, and these other countries to do whatever the heck they want. And they don't have to give you a right to go into court to challenge it. And that was the law. Every Western nation followed that principle until we get to World War II and the Holocaust. And the recognition that it's probably not really good to let Europeans go around and judge other cultures as deficient. That's how we tend to get things like genocide and Dachau. And so what we need is a human rights regime. We need to break down this idea that what happens within the internal borders of a Western civilized nation is solely a matter of their sovereignty. And then we need an international human rights system that first and foremost in Article 1 of the UN Charter recognizes the right of all peoples to self-determination. Great, it's signed. So indigenous people say, what? That means us, right? And oh no, you don't understand. When we wrote that, we really even weren't thinking of indigenous peoples in Western settler states. What we were thinking of was that after World War II, Great Britain and France and Italy and Belgium all wanted to get out of the colony business, and they needed the United Nations to set up the decolonization process. And so indigenous people say, well, we want to get into that process too. Decolonize us. And the geniuses in the UN thought about it, and then actually I was taught by Louis Sohn at Harvard. He was one of the drafters of the UN Charter, and he's actually talked about this in the class I had with him. And they really couldn't get around this principle. How can you grant and recognize the right of self-determination and territorial integrity to peoples colonized in Africa and Asia by the West, but not recognize it for indigenous peoples in Canada, the United States, Australia, Latin America? Well, we need a principle. We've come up with a principle. We will call it the salt water thesis. What do you mean? If your colony is separated by salt water, you can be decolonized. Otherwise, no. That's it? Yes, thank you. Next issue. Nuclear bombs, that's where we're going to take on next. I'm not kidding. And indigenous peoples were very upset about that. Because what they were told was, you can't go to protect your rights under Article 1. You don't have the right of self-determination under the UN Charter. Well, where do we get protected at? Oh, let's see, let's go these, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 27, here it is, Article 27. Way down there, you get treated as a linguistic, ethnic, or religious minority, which means you get to pal around with your buddies, and the state can't interfere with that. So all your rights are going to have to be protected under Article 27. And what happens, of course, is that Article 27 becomes a very poor vehicle because it's very Western-oriented, individualistic rights, doesn't recognize group rights. But countries like Canada are continually relying on the salt water thesis and this idea that indigenous peoples in Western settler states aren't included in decolonization to prevent any examination whatsoever of Canada's treatment under international law of its indigenous peoples. In a case brought by the Mi'kmaq. Remember the Mi'kmaq Treaty? Well, because Silly Boy in other cases said that treaty has no effect, they'd exhausted their domestic remedies, they went to the UN Human Rights Committee. And here was Canada's defense. International, American, and Canadian law don't recognize treaties with North American Native peoples, international documents, confirming the existence of these tribal societies as independent and sovereign states. They are merely considered to be nothing more than contracts between a sovereign and a group of its subjects. Now recognize that if you take first-year contracts, the hardest thing to make students understand is the theory of efficient breach. See, under Western notions of contract law, there's no moral guilt if you decide that it's efficient for you to break a contract as long as you're willing to pay damages. So in other words, these treaties have no moral weight to them, is what Canada's arguing as late as 1980. This is Canada's argument. And so what happens is indigenous people say, this is nonsense, and we've got to get this changed. And so they start knocking on the doors of the International Labor Organization. And they get the ILO to pass the first modern treaty, International Labor Organization Convention number 169, which recognizes the rights of indigenous peoples to self-determination. They go and get a UN working group on indigenous populations. You notice the word populations? And it's very interesting. If you look at ILO 169, it says the rights of indigenous peoples, but there's a footnote 1. And footnote 1, you go, the states were not going to sign anything that said peoples unless it had the footnote. And the footnote said the use of the word peoples here has no meaning outside of this document. So it does not, that's what it says, footnote 1. Canada led the charge on that. Canada would not let peoples go without a footnote. And so when the UN Working Group on Indigenous Peoples was established, states like Canada insisted, no, you can't use the magic word peoples. It's got to be populations. Daily Sambo Duro stuff says, well, populations are seals. I mean, you know, that's not peoples, but didn't carry the day. The OAS. Indigenous peoples demanded the OAS start drafting a declaration on the rights of indigenous peoples. Indigenous peoples started knocking on the doors of other UN agencies, the Convention on the Rights of the Child. major international environmental instruments saying, your system isn't working for us. We're getting slaughtered. We're being subjected to genocide. In countries like Canada and America, large multinational energy development companies are coming in and destroying the few remaining lands that we have. Our forests are being cut down. We need something better than Article 27. And so what they begin to argue is that, okay, if you're not going to give us Article 1, and you're saying we've got to argue under Article 27, which says that you've got to protect our culture. Well, what you need to understand about us is we're a land-based culture. So unless you protect our special relationship to land, which is absolutely essential to our cultural survival, cultural identity, cultural integrity, and cultural security, then we ain't going to be around much more. And so what you've got to do is make Article 27 expand to include this notion of group rights to land for groups that have special, unique relationships and can demonstrate that relation. You know what? The system started to understand. I see, for example, the UN Human Rights Committee, with regard to the exercise of cultural rights protected under Article 27. The committee observes that culture manifests itself in many forms, including a particular way of life associated with the use of land resources, especially in the case of indigenous peoples. And that right may include such traditional activities as fishing or hunting, and the right to live in reserves protected by law. So what you see is the system beginning to respond to these stories told by indigenous peoples. And the system responds to the point where in 2007, coming out of that working group on indigenous populations, a draft declaration on indigenous peoples' rights is promulgated, which is eventually passed by the General Assembly. How many people know the 4 countries that voted against the UN declaration? Let me hear them. Canada, US, Australia, New Zealand. Isn't that interesting? Have you ever thought? Guess what? All 4 countries adopt the English common law doctrine of discovery. That's the reason. You cannot vote for the UN declaration if your system continues to follow the doctrine, because the declaration totally repudiates the doctrine. In its preambular language, it says, basically, don't come in here with any arguments based on these racist principles from the colonial past. Countries don't go using the doctrine of discovery to justify your policies. This is how you justify your policies. And if you read the articles of the declaration, you see they are totally opposite of Canadian law. And that's why Canada couldn't support them and couldn't vote for them. They have the right to the lands, territories, resources they've traditionally owned. States must give legal recognition, and that recognition can't be dictated by the mandates of the government and the BCTC treaty process. That recognition can't be mandated by the test from the Canadian courts, which said to prove an Aboriginal right, you must show that that practice is integral to your culture. You can't do that under international law. Under international law, your recognition process has to give due respect to the customs, traditions, and land tenure systems of the indigenous peoples. The Hul'qumi'num case totally ignores, totally violates those principles. It violates the basic principles, Article 26, just and fair compensation, where you can no longer get the land back to indigenous peoples because you've given it to these wealthy timber companies that want to cut down all the trees. That's not an excuse. You've got to provide restitution, because that's their basic human right. And here's the thing, when I first started out at the UN, a diplomat took me aside and said, you guys got to stop arguing about all the bad things that happened to you in the past. All the broken dreams. We don't care about that. If we tried to fix everybody who got screwed over in the past, we'd have the Turks here, the Armenians, the Palestinians. The only thing we care about, and the only thing this declaration is going to do, is protect your rights to cultural survival, cultural integrity, cultural security, and cultural identity. That's all they care about. It's totally forward-looking. Human rights law doesn't care about the past, only to the extent that it complicates your assertion of rights in the future. So that's why you get restitution. You also get the right to consultation. And that right is understood as a right to self-determination. One of the first, if you're going to be a self-determining individual, you better have information. The government better tell you what the effects of its timber cutting policies are going to be, and the siltation, the damage to the water. They need to do studies under international human rights law. And states shall consult and cooperate in good faith through their own representative institutions, not these treaty groups that were cobbled together by the government. Those weren't indigenous. Those groups sometimes have coherence with traditional alliances, but oftentimes they're just thrown together as a matter of convenience, in which the government says, negotiate this way, or we're not going to negotiate with you at all. In fact, my colleague at the U of A, James Anaya, who's now UN Special Rapporteur, makes the point, and this is the other important point about the Declaration. The Declaration isn't anything new. It doesn't create any new rights. All it says is, oh, the Declaration starts with the assumption that you're not savages and infidels and heathens. It starts with the assumption that you have equal rights to white folks. And if that's true, what does that mean? It means you get the same rights as them. So Jim makes the important point. The Declaration represents an authoritative common understanding at the global level of the minimum contents of indigenous people's rights. It's the product of a protracted drafting process. It reflects and builds upon human rights norms of general applicability. In other words, don't let Canada tell you that this creates some new regime of rights. That's a total misrepresentation of what the Declaration is. The Declaration simply gets the UN system correct by saying, you now get the same rights as everybody else. However, Canada had trouble with that. This was their official statement to the General Assembly when they voted against it. And I do this in America. I do my A accent to sort of mimic and mock Canadians. I won't do that to you here, okay? I'll read it straight, but it's not as much fun. A, Canada's position has remained consistent in principle. A, restated publicly, we have significant concerns with respect to the wording of the current text, including the provisions on lands, territories, and resources. This is what I love.
Oh, take off, eh?
Now, I'm going to stop. Free, prior, and informed consent when used as a veto. Wait a second. Free, prior, and informed consent. What the hell else would you have free, prior, and informed consent for if you couldn't say no? Do you understand how illogical that is? We disagree with FPIC if it means you can say no. So you can only have FPIC if you say yes. Self-government without recognition of the importance of negotiations. I mean, that's what you do with your teenager. You can have the car, but we'll negotiate what time you come back. You don't do that to people and the right to self-determination. That's not negotiable. That's your autonomy. That's your dignity as a human being. How can you negotiate that? And the need to achieve an appropriate balance between the rights and obligations of indigenous peoples, member states, and third parties. Gee, look at the land tenure patterns on Vancouver Island. There's an appropriate balance. What do they got, 97% throughout the province? Indian people have 3%. But this is what they can say with a straight face. And so, faced with that situation, the Hul'qumi'num Treaty Group approached my program and asked, is there a possibility to challenge this system without having to go through Canadian courts, where it's going to take us 20 years and $20 million, or continue to negotiate the ridiculous BCTC process where we already owe $30 million? $30 million. And I said, well, the OAS is interesting because basically, remember what Jim said? That the Declaration simply builds on already recognized rights, norms, and principles? Well, a big source for those rights, norms, and principles came from the OAS system because they've been working on these issues for 2 decades. And so, to give you a basic understanding, you have the Organization of American States. It's a treaty body. Canada has signed on to it. So Canada is treaty obligated to uphold the principles and charter of the OAS. And as I tell my indigenous clients, if they're going to violate their treaty obligations to other nation states in the Western Hemisphere, why would you ever trust them to honor any of their treaty obligations to you? So this is really a test. If Canada can't follow its treaty obligations under the OAS, they're not going to do a very good job with other First Nations. And in fact, that's exactly the position that our amici who had signed treaties, Inuit, for example, Inuit in the Northwest Territory signed an amicus brief which said, we signed a treaty with Canada, don't do it because they don't honor their obligations. They said that in black and white. So the commission is comprised of 7 independent experts, and they interpret the American Declaration on the Rights and Duties of Man, and they'll take complaints from citizens from countries in the OAS like Canada to see whether or not Canada is living up to its treaty obligations to protect the rights guaranteed under the OAS Declaration. And what are those rights? Well, all persons are equal before the law. If you recognize the white fellow's property rights, you got to recognize the brown fellow's property rights. And every person has a right to own such private property as meets the essential needs of decent living. So you put those two together. Canada has an obligation to recognize Indigenous people's property rights and to treat them equally. And I think we all know in British Columbia, that's not happening. In fact, there's been a lot of jurisprudence developed out of the inter-American system that the working group relied on in developing the Declaration. The first major case decided was Agostini in Nicaragua. There, the indigenous peoples of the Atlantic coast of Nicaragua had been in possession of their lands for 10,000 years, and the government, without consultation, without any offer of compensation, never a treaty, grants a timber concession to the literal heart of the territory. And the Mosquito Indians came to my colleague at the time, who's now UN Special Rapporteur, Jim and I, and asked them to bring a case challenging that action. And the Inter-American Commission issued a finding, which was then affirmed by the Inter-American Court, that Nicaragua's failure to recognize and respect the property rights of indigenous peoples and to treat them equally constituted a violation of the American Declaration. For indigenous communities, that second paragraph, relations to the land are not merely a matter of possession and production, but a material and spiritual element which they must fully enjoy, even to preserve their cultural legacy and transmit it to future generations. You see there? That idea that international human rights law isn't concerned about what happened yesterday or 100 days ago or 100 years or what Joseph Trutch did. They only care about one thing. You, Canada, have the absolute obligation to guarantee and protect the cultural survival, cultural security, cultural identity, and cultural integrity of these people. And if you're not doing it, you're in violation of your treaty obligations under the OAS. And Nicaragua was found to be so. Building on that case, subsequent cases further developed these principles. The Dan case out of the United States, where property and user rights of indigenous peoples arise from rights existing prior to the creation of a state. Indigenous peoples have the right to recognition, and their title can be changed only by mutual consent. And then finally, one of the most important judgments is the Saramacca case, because it talks about the situation we confront in Vancouver Island. You had a situation where the government had not demarcated or titled indigenous people's property, yet the government was continuing to issue mining and timber licenses, saying until you prove your title, you have nothing under the Doctrine of Discovery. So we don't have to recognize it. That's exactly the situation. That's why this is the not so special case. That's the situation of every First Nation in British Columbia that has not had their rights recognized by treaty or court decision. The government can continue to issue permits because under the Doctrine of Discovery, the government has the superior right. And the Commission says very clearly, no, you have to ensure the effective participation of these people in conformity with their customs and traditions. I've sat in on some BCTC negotiations. I can assure you they are not held in conformity with indigenous people's customs and traditions. The terms are dictated. The state must guarantee the Saramacas until, and here's the leverage, and this is the key thing, that if this is the only thing you would need to change in Canadian law to change the entire equation. Okay? And that is, until you go through this arduous, long, complicated process of demarcated entitling, you can't interfere with their use and enjoyment of the land. You can't issue tree licenses. You can't issue mineral licenses. How do you think the extractive companies would feel about that? What do you think they do? They'd call up the Premier, they call up Harper and say, get your butt off that chair and start negotiating so we can start cutting those trees down. At least some of them. If you change that leverage, and that's exactly what international law requires. Because why? Because cutting down the trees and mining on this land without the indigenous people's consent will probably affect their cultural integrity, identity, survival, and security. And that's a no-no. And the state must ensure no concession will be issued unless and until independent and capable entities perform a prior environmental and social assessment. And why do we do that? They are intended to preserve, protect, and guarantee the special relationship that the members of Saramaka have with their territory, which in turn ensures their survival as a tribal people. Do you see how this language of human rights is so different from the language of savagery that your courts speak? It isn't concerned about proving postage stamps or territoriality. It says, what are you doing to make sure that you're not exterminating these people's existence? That's all it cares about. It's a totally different way of looking at Indigenous people's rights. And unfortunately, too many Canadian lawyers don't know about international law. They haven't studied in school. They don't think it's important. So they went down this horrible road 30 years ago, beginning with Delgamuukw, in which they basically tried to make the master's tools dismantle the master's house, and it will not happen. Audre Lorde, the master's tools were not made to dismantle the master's house. Duh. Tell that to your lawyers. They're making $500 an hour until somebody calls them on it. But you are never going to get justice under this language of savagery that's used by your courts. Now, luckily, the UN system, the human rights system, have been on Canada's case, beginning as early as 1999, telling Canada that the way you deal with Indigenous land rights is in violation of the human rights of Indigenous peoples. We recommend Canada reform its laws to guarantee the full enjoyment of rights over land. Additionally, the committee recommended that Canada abandon the practice of extinguishing inherent Aboriginal rights, which basically says you can't use the doctrine anymore. Instead, this is what Canada comes up with in the BCTC process. And if you want to know why so few treaties have been signed, how come those Indigenous peoples are so, I don't know, stubborn? How come they're not compromising? How come they don't want reconciliation? Here's why. Private lands. All those lands I showed you that were taken, they're not on the table. They won't talk with HTG about private lands. It's just a small sliver of crown lands left. If you know that area over there, you know there's not much crown land there. Just compensation is not on the table. This is what your geniuses in the Canadian Justice Department tell the Inter-American Human Rights Commission. Human rights. Get that? They're saying, well, this has nothing to do with rights. This is a political process. Therefore, it shouldn't even be before you guys. Modified rights. A non-assertion model. In other words, if you sign a treaty, you agree that you'll no longer assert any Aboriginal rights to any of your land. And in fact, if you do, you've got to pay us. If one of your members sues us for a violation of Aboriginal rights after you sign the treaty, there's an indemnity clause. And you have to pay us, and we get to pick the lawyers. Oh, also, if you're in negotiations and we decide to cut down all your trees, because under the Doctrine of Discovery we can do that, if you go and get an injunction, we shut down the treaty table because you can't sue us while we're negotiating. That's not good faith. Well, but you're cutting down our trees. Well, we have the right. The loan policy. Basically, it's Robin Hood in reverse. The government loans money to the First Nations so they can have the capacity to negotiate for HTG over $30 million, and that money's going to come out of the eventual treaty settlement. So doesn't it make sense? The longer the government negotiates, the bigger the loans. So what incentive do they have to sign a treaty? Not only that, if you sign a treaty, you can't cut down the trees anymore. This is why it's in the government's interest to drag on these cases as long as possible and to drag on the treaty negotiations, because there's no penalty for it. There's absolutely no penalty. And again, in 2006, so Canada says, oh, we can't use the extinguished word. That gets people upset. So we're going to try the modified rights. And this, Canada, the arrogance, because they really think people are stupid. Okay, they think we're going to go from extinguished to modified. While noting the state party has withdrawn since 1998. Remember that report that I showed you was 1998. The requirement for an express reference to extinguishment of Aboriginal rights and titles, either in a comprehensive claim agreement or in the settlement legislation ratifying the agreement, remains concerned that the new approaches, the modified rights model and the non-assertion model, do not differ much from the extinguishment and surrender approach. They're fooling you. They're fooling you. But they're not fooling the international human rights system. You're letting them fool you. That's what you're doing. And so we filed a petition. And this petition doesn't speak the language of racism, the language of the Doctrine of Discovery. It speaks the language of human rights. By unilaterally granting rights and interest in the lands of the Hul'qumi'num people to private third parties without consulting them. You can see, I'm getting everything in here. Okay, I'm getting the right to consultation, I'm getting property rights, this is how you got to do it. no offer of restitution, payment of just compensation, permitting damaging logging and other development activities, occupied and relied upon by the Hul'qumi'num for their cultural survival. That's all I'm focusing on. That's all this case focuses on. That what you're doing in Vancouver is leading to the ethnocide of the Hul'qumi'num people.